Hello, everyone, to the second series of our podcast. And today we'll talk about transport order. I'll be joined by Otmar Tuma, who has recently held an excellent workshop about the transport order, its clauses, and its significance in case something goes wrong. And today he will share with us our ideas how we could actually use this blank sheet to our benefits. Welcome, Otmar.
Thank you.
So without any further introduction, let's go forward to our key topic of today's podcast, which is a transport order. Now, if you talk about transport order, it is important to mention the Samar Convention and the Article 41, which is one of the cornerstones of the convention. And it tells that you can't rewrite the rules as you see them fit. The rules are in the articles, which is 51, and most of you know them by heart. But what is important, what matters more is what is not in those articles, what is not being told. And this is kind of a gray area, the area where you can improvise, where you can create your own rules. And transport order is a perfect tool for that. It's not only just a paper where you tell where to load the goods and where to bring them. It's basically look at it as a blank sheet where you can dictate your own terms, which will come to your own benefit in case, things go wrong, in case there is a claim. And, as we know, the claims happened. So use this for your own benefit. I mean, always before implementing and changing transport order, it's advisable to talk to your lawyer on what will be the legal implications. So this is what we will talk today will be only on recommendation basis. But please consider the transport order. It's just not for the piece information. It's much more which can play to your own benefit. Okay, so let's head forward to the first clause. Today's clauses will be divided into two separate parts. The first one will be the more relevant for haulers, well, with some exceptions for freight forwarders. And the second part will be those that will be relevant for freight forwarders. Now, both parts are important for all sides because if the clause is benefiting haulers, so the freight forwarder should be aware of that as well, as it's not going to play to his advantage, and he should be just looking for that in the hauler's transport order. So let's start with the first one part is the most important for haulers, and the first clause talks about high value goods. All the clauses will be posted later on, so you'll find them. So the high value goods is that the principal should inform us about the delivery of a goods with a high value in due time, so that we can arrange provision for a transport with relevant precautions. Why this clause is important, Otmar? Maybe you can just share some thoughts or ideas. What's behind it?
It's very much important in regard of Article 29 CMR, which states that the carrier has an unlimited liability in case of willful misconduct. In some countries, because of court decisions understood as also gross negligence. And so especially in German courts, it's very popular, even in the Supreme Court of Germany, to focus on the value of the goods and on the fact that or not the sender has informed the forwarder who concludes a contract of carriage or the haulier who concludes a contract of carriage about the value of the goods. And especially German courts focus very much on the fact that if this value is told, this higher value is told, then the forwarder, respectively the carrier, has to take much more precautions to avoid the claim. Usually, of course, it should be the utmost care, but here it's one level higher.
So you're telling that it's even the opposite, that it should be also the intention of a shipper or, the freight forwarder to reveal the cargo value, because if he's not going to tell that you're bringing something valued at 1 million euros, then the hauler might try to use to his own defense that, look, if I knew that I'm bringing mobile phones, I would probably took a different rest stop.
Yes, but this is not a general rule. It's nowhere written except in court decisions. And the court decisions in CMR countries very much differ in the approach. I'm mainly now here reflecting the German approach.
Okay, understood. But if we talk about high value, it can be, a very subjective term or definition. How you would define what is, I don't know, if, for example, a screen or, washing machine, for example, is a high value goods or not? What is the point where?
Yeah, there's also no definition about high value goods. But if you look at yourself, the dress you wear, the shoes, whatever you might have, bracelet, or so, and if you put it in if you try to weight it, it might be 2 kilograms. But if you buy it, you pay, I don't know, 200, 300 euro. So this is in no proportion because normal liability, according to Article 23.3, would be for 3 kilograms 30 euro, but you have paid for normal dress you wear maybe 300, so it's 10 times more. And this is because when 1956 the CMR was created, at that time 25 gold francs, but nowadays 833 special drawing rights per kilogram were, if you convert it nowadays, approximately 60 euro, so 6 times more. But there is no inflation clause or something like that in the CMR, and therefore claimants tend to more and more stress Article 29 CMR or their cargo insurers to get full compensation. And that's why carriers, respectively forwarders who conclude contracts of carriage, need to protect themselves and try to shift a little bit the risk to the sender. So if the sender doesn't specifically tell about this high value of the goods, it might help in some courts.
I think another point of view in that almost all of them have a certain clause which talks about high value goods, and it is either some local insurance, for example, completely exclude like spirited liquids or electronics. Some of them set the limit. Let's say like you can bring the electronics up to, let's say, 200,000 or 300,000 euros, and some of them limit your liability. So basically, maybe the advice would be that when, especially referring to the high value, we can refer to their own insurance terms, what is considered as a high value, just that, to be on the safe side if claim happens and it turned out we are bringing some tobacco or spirited liquids.
Yeah, absolutely. This should not be forgotten, that you check your own insurance conditions and compare it with what is on the market as the best offer regarding insurance conditions. There are so many different kinds of exclusions in various countries. Even there are different customs in different areas. So it's very important to get a really good overview about what is offered on the market, and we're talking about the EU market. So a good broker should know and should advise you properly.
Yeah, Mark, but just a little bit question on the side. Actually, if we talk about high value and we talk that, well, we agree that most cargo liability insurance programs have their definitions of what is cargo value. Let's say it says that, you shouldn't bring, for example, electronics, which are valued more than 200,000 euros. What would be, I just want to hear your opinion. So, because nowadays there is a problem that the shippers usually doesn't bother to reveal not only the cargo value, but the nature of the goods. And if it happens so that, for example, I don't know, the hauler has taken electronics, let's say €500,000 worth, without knowing them, without knowing what is the nature of a cargo, and his insurance policy has a limit of only that, 100,000 euros, for example, is you can't bring anything more valid. How it will be in case of claim? Do you think the insurer will reject the claim in that case?
I think so. But on the other hand, no carrier should have an insurance policy with only 100,000 euro compensation limit. Taking into consideration that there are goods which might have even more than 1 million euro. And I personally had a claim case to handle with 1.7 million euro. It was 4 tons only PlayStations, and the carrier didn't know that it took it over. It was without prior information from the sender. Every carrier should look for an insurance policy with really high insurance sums and with only few exclusions. And such products are on the market.
Yes, that's right. Okay, moving to the second clause. The second clause talks about how the ruler is going to carry out the void, that one drive is going to be used, and that the stops will be done at the parking areas or rest stops. It tells that, unless confirmed by us separately in writing, we use only one driver per truck, as is international customary, and the principal explicitly agrees that the trucks can also be parked in parking areas unguarded at the roadside, in particular during the necessary breaks, also during the night or over weekends. And later on, the clause continues that if you would like, we can employ 2 drivers that will be done at additional costs. My question would be just coming just straight on this clause. So basically, you are just like kind of revealing to your customer that, look, I'm going to use one driver, and I'm going to park probably at unguarded areas and etc. So your customer is aware, and you give an option that if you're concerned about that this might bring some, I don't know, risk of theft, then you can employ 2 drivers. So let's say a theft happens, of course, just in unfortunate circumstances. Would this clause be a basis for the hauler to dispute the liability on the ground that, look, I gave you an option to employ 2 drivers and to avoid this risk, and you, in the transport order, you haven't selected that?
Not to dispute the liability in principle, but this clause might help to avoid that Article 29 is applied, or at least it could lead to the conclusion, if the case goes before a court, that Article 17.5 would be applied, which means that the responsibility for this occurrence would be split between the sender, who was aware that he exposes the goods to a higher risk if only one driver is used, and on the other hand, the carrier, who, of course, in any case must act with utmost care. This clause was originally created because there are approximately 15,000 lorry thefts every year within Europe, and approximately between 6,000 and 7,000 out of this in Italy only. So it's more in Italy clause, I would say, but also Great Britain is very endangered. And there are court decisions indeed where it says if the carrier offers a second driver, but the sender doesn't accept his offer, then he is kind of co-liable for what happened.
Or I think it's, I don't know, personal for me, I think it's more important that it openly tells, look, we're going to be probably parking at some petrol stations on guarded areas, and this simply draws a line if, there is a theft, which is, unfortunate and really unpleasant experience for any shipper. And they initially might have some intentions to claim for, gross negligence or willful misconduct that you have been parking at petrol station, even it's been, the usual practice. So it basically draws a line that, look, you won't be able to do that, and brings on a safe side.
Yes, what you say, parking on petrol stations. Talking about Italy, it's often even not possible to park at petrol stations. Many carriers, many drivers choose to park on an inlay at the highway because all parking places are completely full. And if you drive on the highway in Italy and look on the left and right side and to all these unguarded parking places, every one of these truck is on risk if it's stolen, that's the case of Article 29 CMR, which on the other hand is very unrealistic, that courts expect that every truck is parked so that nothing can happen, because the problem is there are not sufficient parking places. And therefore, we need to create these kind of clauses to protect the carriers, at least a little bit, from a legal perspective.
Okay, well, I thought that parking at roadsides is a little bit extreme on a safe side, not to a positive thing, but yeah, you're probably right that sometimes the rule is just driver is happy that he can find at least any place to park in that position. Okay, moving forward to the third clause, which talks about who is responsible for loading, stowing, and securing, and it tells that the principal or the consignor shall exceptionally be responsible for loading and unloading, treatment, stowage, and securing of the goods, as well as for securing cargo and packing the goods. And the driver shall not be obliged to check the loading method and how the cargo has been secured. Am I understand correctly that this clause comes from Article Convention 17.4, which tells that if a shipper loaded the goods, then the driver is not responsible for losses due to that? Or
Yes, you're correct. I mean, the CMA itself doesn't provide a solution or a regulation who has actually to load and who has not. It's just an exclusion clause for the case that the sender loads. So first thing we need to look at is there, in regard of the applicable law of the contracts in principle, is there a regulation who has to load? It might be that in the applicable national law, there is a provision that the sender has to load or the carrier has to load. And if this is an obligatory law, a clause cannot help, which contradicts obligatory national law. But on the other hand, many countries have no regulations like that. So we need to create a possibility for the carrier to shift the responsibility towards his principal, and this is the clause what is just on the screen. So on the other hand, if there would be no such agreement, we simply have to look how the courts decide in different countries. And in some countries, it's obvious, and in the most countries, I would say that usually the sender has to load. But there might be some countries where it's not the case, that courts decide that way, and then this clause would help.
yeah, it's right. I think the prevailing opinion is that, a driver is responsible for actually driving from point A to point B unless something else has been agreed. But as you told, there are some countries where it's an exception to the rule and some other practice prevails. But basically, the question for me is just, I'm just interested about the part which tells that the drivers shall not be obliged to check the loading of the goods, but we know that in some convention in Article especially 8, the driver is obliged to check the quantity of the goods and just the general, marking of the cargo. And so, do you think if, for example, the driver sees that the loading is not securing, for example, not loading, securing is not professional, or he's not going to be able to deliver the cargo in safely manner, this clause would save him, or just he still carries some liability and he should reject this cargo?
And now, if it's obvious in an ex post view that the driver must have seen that the loading was improper, he has the obligation to warn. This obligation doesn't derive from the CMI itself, but from a general principle which in the most jurisdictions would apply. He should warn the sender and say, if the goods remain loaded in this way and there is no improvement in the way that it's loaded, most likely a claim will occur during the transport. There's also the obligation of the driver from the viewpoint of a public liability to prevent that improper loaded or improper stowed goods might fall from the truck that's not about CMR liability, but it's in the interest of the carrier, of course, to have an eye on the loading and to warn the sender. And if he does, and still the sender insists that he starts with the transport, provided that it's not a loading which might endanger third parties by goods falling out of the truck. So if the driver wants, the sender rejects to do anything, and the warning is obvious, maybe with a remark in the CMR consignment note or so, then it's most likely a case of Article 17.5 CMR, joint liability.
So with all the benefits of this clause, it shouldn't mean that the driver is completely off the hook and he can just simply ignore how the cargo is, positioned in the truck or secured. He must still do this, like a common sense actually checks of whether he will be able to safely, deliver these goods. And if he sees something, he must warn about that.
Yes, I agree. Common sense is a proper word for this, yes.
So we are moving on the next clause, which talks about the writing, and it basically talks about the agreements that the shipper might pass on a last minute to the hauler or to the subcontractor. And basically it tells that agreements of any kind, including deviations from these terms and conditions, shall be made in writing, and neither our subcontractor nor the driver shall be entitled to supplement or modify the agreements. Therefore, the driver shall be in particular not be entitled to sign a declaration of commitment when issuing custom documents. So if I understand Otmar correctly, this talks about that when a driver arrives at the loading place and the shipper might want to put something into the waybill or to pass some sort of other document to sign him, just to protect hauler's interests, right?
Yes, that's right. I mean, that the carrier should know in advance what his obligations are. And if the driver arrives at the place of loading and would change the agreement, it might be that the carrier, if there are special risks, never would have accepted this transport order. So it's very important to have everything in writing, because it's about the requirement to be able to prove agreements if something bad happens. Oral agreements are hard to prove and might lead to unnecessary disputes between the parties, which could damage business relationships. And so also the driver should not be able to intervene into this.
But what kind of agreements can it be? One thing which came to my head right now is we talked before about, or we'll talk later about declared value. So just the shipper might try to declare the value in the waybill. Just let's say you're bringing something 500,000 or 1 million worth, which might change the approach of a hauler. What else can be, made such a difference?
But I think it's about to have in advance this agreed with between the carrier and the sender, because the carrier needs to check if his insurance policy provides coverage for Article 24 liability, which could be very high if the value is very high. And usually CMR policies have a clause which says that the carrier and the insurer must specifically agree about coverage for Article 24 or also 26, because these are very exposed risks.
Yeah, that's right. But okay, let's look at it a little bit from other point of view. Let's say, I don't know, we have a CMR convention article, I think, 8, which tells that the driver should inspect the goods and should make any notes if he sees that, some sort of packing or storing or whatever is not allowed. So this article is not limiting this obligation of a driver to make a note about improper packing. I mean, we are not contradicting each other. Because we're telling in this clause that the driver is not allowed to make any notes, but when the CMR convention says that you must make a note on the, let's say, improper inspection of the goods or whatever, or improper goods packing or.
Yeah, but this clause is mainly about modifying the agreement, right?
Okay,
Which was
yes,
made before.
you're right. Yes, you're right. So this clause addresses that whichever we agreed in the transport order can be changed without our written confirmation, and anything else goes as a standard procedures in the waybill.
Yes, correct. Mm-hmm.
Okay, understand. Thanks.
I agree. Yeah.
Okay, moving forward to the next clause, and the next clause is talking about the quantity of the goods, and it tells that acceptance of cargo by units quantities as well as examination of weight and packing are considered as agreed upon. If a shipper refuses this, the driver shall make a note along with the explanation on the waybill. Do you understand it correctly that this clause tells that, if we agreed that the shipper will load 7 pallets and the driver arrives at the loading place and the shipper is giving him, 240 boxes, then this is, not what we have been agreed, or does it talk about something else?
Oh, okay, I understand. Yeah, we have to have a close look to Article 8 CMR. And here it says that the carrier shall check. By the way, shall is really should, as courts in many countries understand it, and not shall, as it's normally in legal English laws used as has to. It's really should, and it makes sense because of Article 29, Article 9. Otherwise, why would there be a shift of burden of proof? Well, Article 8.1 says that the carrier shall check the accuracy of the statements in the consignment note. Yeah, so that means in the consignment note there can be 200 boxes or even 1,000 boxes. Now, of course, the driver cannot count this, especially if the goods are loaded by multiple people from the sender. So he has the tool to make a remark in the consignment note that he was not able to count because of, let's say, he was absent when the goods were loaded, or the goods were loaded at a docking door and he was not even possible to see what's loaded, or he took over an already sealed container, or he was absent to sign some papers in the sender's office. So it's very important that the driver uses the tool of Article 8 and 9 CMR to make remarks in the CMR consignment note if the marks or numbers or the amount of goods he takes over or the outward appearance is not okay. Because it's all about a shift of burden of proof. If the driver doesn't do this, and the claimant claims that not a proper number of goods was delivered, then the carrier has to prove that he took over less, for instance, than stated in the consignment note. And this could give serious problems to the carrier to prove that he was, sometimes it happens, was tricked by the sender, because the sender intentionally loaded not so many like in the CMR consignment note would be stated, because staff of the sender, I don't know, bottles of whiskey, they drank them and they were not there when they had to load. You know what I mean?
Yes. So, but if we're generally speaking about the pallets and the boxes, as I understand, it's the intention of the shipper also to load in the pallets and just to try to load as big a quantity as possible and to avoid the definition of a boxes in the waybill. Because if a driver is going to, let's say, object it and say, okay, I can't inspect, let's say, 220 boxes, when it leaves this just open gap that, if some boxes will go missing during the voyage, I mean, you won't be able to hold the carrier accountable. So the bigger the better.
Yeah, I mean, of course, there might also be the problem that the boxes are stored on pallets, and in the middle of the pallets, there is an empty space, and there are 20 boxes not stored in the middle of the pallet. So there are a lot of tricks which can be used by senders or by consignees, and therefore the carrier needs to protect himself properly in using these possibilities the CMR provides in Article 8 and 9 CMR. It's very important that carriers educate their drivers to use this. And there's a column 16 in the CMR consignment note regarding remarks of the driver, of the carrier. And this field, this column, the driver should use.
Yes, definitely. Okay, moving forward, and the next one is talking about withholding the cargo. So it basically says for all the claims due and not yet due, we shall be entitled to right to offer retention of lien concerning all goods and assets in our possession, and after an appropriate consideration of interest of a principal, a sale by a private treaty is also permitted. So do you understand it correctly that it talks about when the hauler, for example, the shipper or the freight forwarder owns, let's say, for example, a freight to the hauler, and it basically gives them an option that, okay, we are able to withhold your cargo and salvage sale if you doesn't pay all the claims, or it talks about different situations.
Yes, the clause is it's a third word here. Claims doesn't mean a claim, loss, damage, or delay. It means a kind of title. It refers to, let's say, unpaid freight charges from former transports. And so the carrier can take goods which belong, of course, to the party who owes these freight charges as a lien. It cannot be goods which have nothing to do with the actual sender who owes the freight charges. And then there's a possibility to retain the goods or keep it as a lien, but as the CMR is silent about this, before using this tool of retention or lien, a careful carrier should check the applicable national law, how the regulations are there, and if it's allowed according to the applicable law.
So I would say that this is a very extreme, and the first advice probably would be for a hauler to check if this is the same shipper's cargo, because if he's receiving cargo from freight forward, it might be different shippers, and you might be in dangerous waters for salvage selling another actual owner's goods. And the second one is, I guess it's always common sense to give as much notifications or warning as possible actually about your intentions. In that case, just it's not that you wrote this clause in transport order and you're entitled to do anything you want without telling. Actually, you have to warn in advance that, look, if you don't act, we will do this.
Yes, I agree with you. But the main thing is to check what's applicable national law there's about that. If there must be warning, there must be maybe a 14 days period to give the senders a chance to pay or something like that. If this would all be contained in this clause, the clause would be very long and could contradict the applicable national law. Therefore, it leaves it pretty open and shifts responsibility to the carrier to check if this is actually really allowed by the applicable national law.
But, I guess it applies to all the clauses which we're discussing today, because, the law practices differs in many countries, and you have always to be aware that there might be some with gray or shady areas which are discussed in court decisions that you must check actually before implementing.
Absolutely, you're right. And therefore, there would also be the possibility to agree on a clause which law should apply to the transport contract.
Yes, it's, I guess, the next one clause, which talks about legal jurisdiction and tells that in accordance with Article 31, Amsterdam and London may be elected as additional places of jurisdiction. Why London and Amsterdam? What is special about these two?
Before I answer your question, okay. This is about the competent courts. You could agree, but another clause would be to agree on a specific national law. You are free to agree on that, and then these courts would be obliged to apply the national law which was agreed on. But if there's no agreement about the applicable national law, then you just have to look at the Rome I Treaty, which is about which law is applicable to a transport contract. Okay, well, regarding this clause you're just showing, so why Amsterdam or London? Well, there are countries where the courts are carrier-friendly and other countries where the courts are sender-friendly. And if we want to protect the carrier, against, and this is a main point, an unlimited liability in case of Article 29 CMR, we should choose, or the carrier should choose, a court which does not rule that gross negligence is to be considered like willful misconduct, as it says in Article 29 CMR. It's not the same. And for instance, Dutch courts say there is no equivalence between gross negligence and willful misconduct because the Dutch law does not know such an equivalence. And therefore, only in cases of pure intent, which very seldom happens, usually the court in the Netherlands or in England rule that there is full liability. Normally, the sender is used the carrier, not the carrier is the sender. So let's think about a case of a lorry theft, and I had myself to deal with one with 4 ton Sony PlayStations with a value of 1.7 million euro. So normal liability according to Article 23.3 CMR with the 8.33 special joint rights would be approximately 40,000 euro. But like I said, actual value was 1.7 million euro. So what to do? We, for the carrier, sued the sender in Amsterdam and made a application for a negative declaratory judgment, requesting the court to rule that there was no liability, or if there was a liability, then limited with 40,000 euro regarding Article 23.3 CMR. It was a case where a driver stepped out in the night from his truck because somebody knocked on his windows and suddenly looked into 2 pistols, and the goods and the truck were stolen and never found again. So we were successful, and the payment was 40,000 euro instead of 1.7 million. That's the tool carriers should use if they transport high valid goods, and there is a danger that Article 29 CMR with unlimited liability would apply.
So basically it means that if you're a hauler and you're facing some really severe situation, like the possible implication of willful misconduct, and you have an option to refer to, let's say, Amsterdam or some other country jurisdiction which is favorable to law, it's we should explore options not to sit and wait till the shipper is going to sue you where he prefers, but to be proactive and to approach the court. I don't know the legal definition, but with request to, let's say, determine availability or the maximum availability amount.
Absolutely, the carrier needs to be very fast. It's not about only about choosing the right forum. It's about running to the right forum. So therefore, the expressions forum running, and it's because Article 31 CMR regulates that only one court case can be held between the same parties based on the same grounds. So if the sender, or very often with high valid goods, it's a cargo insurer, is the first to sue the carrier, and he will do it in a country which is in favor to the sender, then the case is most likely lost for the carrier. Therefore, the carrier needs to be fast and to choose the court he favors.
I think we had a situation where there has been a question of an hours whether the Lithuanian jurisdiction will prevail or just, as you told, the judge actually. And I think on the free folder hauler side we won because we have applied like a couple hours before actually the same claim has been filed in the Lithuanian court. So yeah, time is an essence.
Yeah, it's also about when is a claim pending, like Article 31 requires. And this depends from the national law. It can be that the writ has to be served actually to the defendant, and then it's only pending. And in other jurisdictions, it's already when the writ is with the court. So it also depends from the national law. But overall, I can say it's the most favorable for carriers is the Netherlands, and therefore we recommend the Amsterdam court. There are also a lot of specialized lawyers who deal with this kind of stuff almost every day.
Okay, so the holders should note that if there will be in some extreme situations.